The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. This is Jennifer Schaus coming to you live from Washington, D.C., and we are continuing on the first week of our 2017 summer series of government contracting webinars. Thanks, everybody, for joining us today. We are joined also with Ed Delisle, who will be covering the Rule of Two, a very hot topic in government contracting. We'll get into his presentation in just a moment. Like I mentioned, this is the first week out of 7 weeks of government contracting webinars. They're very short and sweet, concise, and to the point, so only running about 20-30 minutes. They're all recorded, and the full list of our webinars are on our website under the webinar section. The recordings at the end of the week will be posted there as well. So in the event today you need to jump off early, or if there's something that you want to attend that you're going to be unavailable for, certainly go back to our website and check for the recordings. A little bit about us, based in downtown Washington, D.C., and provide various services offered typically a la carte for government contractors. This ranges from GSA schedules, 8A certification, proposal writing, capability statements, and other related services. Additionally, we do host government contracting networking events and seminars in person, so check our website under the events section or jump onto our newsletter, which now reaches about 11,000 subscribers to stay abreast of upcoming events, webinars, and seminars. My background is listed there. That's not as important as our speaker today, Ed Delisle, and as I mentioned, he's joining us to speak about the Rule of Two. So Ed, thanks again for joining us. I'm excited to hear your presentation, and I will certainly hand the controls over to you now, and the floor is all yours. Thanks.
Okay. Thank you, Jennifer, and welcome everyone for joining us this afternoon. As Jennifer mentioned, the Rule of Two is a very hot topic in federal government contracting at this point, and we'll spend maybe 20 minutes or so going through why it's important and why it's a hot topic. You'll see there a little bit about me. I'm a Philadelphia person. I have a office here in DC, and in fact, I'm talking to you live from Washington, DC today, but I spend probably about 70% of my time or so in Philadelphia, go back and forth. And my firm, there's a little bit about it. I've been at my firm for a long time now, 19, 20 years. It's gone by very fast. When I joined my firm way back when, I was the 10th attorney. Now we're up over 60 with various offices across the Mid-Atlantic region. My specialty is federal government contracts. I'm the co-chair of our federal contracting group here at the firm, and you'll see some of the services that we provide to our federal government contracting clients. All right, so without further ado, we will get into our topic this afternoon, the Rule of Two, and why it's important to government contractors. All right, so we deal with the Rule of Two, or we can deal with it in different contexts. There are two different sort of general categories. You have the broader aspect of the Rule of Two, which runs across the federal government, and then you can run into more narrow versions of the Rule of Two, and we'll talk about both of those. Generally speaking, as we state here, the Rule of Two requires that the government set aside acquisitions or contracts, and contract as it pertains to this particular area is a rule of art, and we're going to get into the definition of a contract as part of our discussion today. But the government shall set aside acquisitions or contracts over a certain dollar threshold for small businesses when there's a reasonable expectation that two things will occur. One, that offers will be obtained from at least 2 responsible small businesses, and 2, the award can be made at fair market prices. And what you're seeing there is the broader context within which you'll find the Rule of Two, and that spans across all government agencies, and it is found codified as part of the Small Business Act at 15 U.S.C.A. 644J. It was subsequently modified by the addition of 644R at some point more recently over the last few years in an attempt to deal with some of these issues that have arisen with respect to when it should or should not apply. From a broader perspective, the certain dollar threshold area that we're talking about here is actually a range. We're talking about a range of, as it stands now, acquisitions from $3,500 to $150,000. And that band of acquisitions or contracts is the band within which the Small Business Act will apply. Now, as I mentioned previously, you see the rule of two also applied in other contexts, and in particular, as we see here, in what's become known as the Veterans First Act. There is a rule of two identified within the statute that established Veterans First. The statute is 38 U.S.C.A. Section 8127, and the Veterans First Act states that the VA shall restrict competition to VOSBs and SDVOSBs, that's veteran-owned small businesses and service-disabled veteran-owned small businesses, when the rule of two is met, which occurs when the contracting officer can reasonably expect, based on market research, that at least two eligible small businesses will submit offers and that the award can be made at a fair and reasonable price. And as you can see there, the statutory language of the Veterans First Act is very similar, if not identical, to the Small Business Act, which is identified directly above. And what you will see as we carry on and get into the Kingdomware case, the Veterans First Act and the application of the rule of two there, which is the subject matter of Kingdomware, has broader implications based upon how that particular case, the Kingdomware case, played out through the Supreme Court's opinion. Let's talk a little bit about Kingdomware. The decision by the Supreme Court in the Kingdomware case is now just a little bit over 1 year old. It came out just about a year ago, and it has been much written about. It was very important at the time because it had been quite some time since a federal government procurement case had reached all the way to the Supreme Court. And for practitioners that operate in the field that I operate, there was much discussion about two specific issues, and both of them are here. And as the case itself progressed and matriculated through the appeals process and eventually got to the Supreme Court, those issues changed a bit. The facts of the Kingdomware case, as you see here, are as follows. The Department of Veterans Affairs issued a solicitation seeking emergency notification services, and ultimately the VA retained a non-veteran-owned business to provide these services, and it did this through the Federal Supply Schedule, the FSS, which of course is administered by the GSA. So this was a VA solicitation. It was a VA procurement, and the Federal Supply Schedule was used for the purpose of obtaining the service that the VA wanted. The plaintiff in the case, Kingdomware, challenged the issuance of the solicitation generally, and more specifically, took the position that the Department of Veterans Affairs was required to go through a rule of two analysis to determine whether a VOSB or SDVOSB had the capability, or at least two of them had the capability of providing the services that the VA was seeking and could provide those services at fair market value. So in other words, the plaintiff took the position that under the Veterans First program, the VA it was mandated to go through that rule of two analysis before allowing it to go to the services, before allowing the services to be procured from a non-veteran-owned company. And the issues presented there, you'll see the first one that I just mentioned. The alternative there. See, when we went through the Rule of Two, and this is the same with whether we're talking about it through the Small Business Act or we're talking about it here through the Veterans First Act, there is mandatory language in each Rule of Two, that whether it's the Small Business Act or whether it's the Veterans First Act, the same mandatory language appears that the federal agency or with respect to the Veterans First program, the VA shall award contracts as identified in each one of those statutes if the requisite small businesses, or in the case of the Veterans First program, VOSB or SDVOSB firms can be identified. Well, here one of the issues that was presented through the litigation was whether or not that mandatory language could be waived if the VA otherwise met its VOSB contracting goals. And we're going to talk about what that means momentarily, but that particular issue changed as the case went through and graduated up from the Court of Federal Claims to the Federal Circuit and eventually got to the Supreme Court. That issue was effectively abandoned by the government. It was the primary driver of the government's position as it went through the litigation process, but by the time it got to the Supreme Court, for lots of reasons which we don't necessarily need to get into here, but the government made the decision to effectively abandon that argument and to pursue a different one, which actually will become very important as we go through our discussion today. And ironically enough, by arguing that it was possible to waive the Rule of Two requirements based on meeting or projecting to meet statutory goals, meaning that certain percentages of the work were supposed to end up in the hands of VOSBs or SDVOSBs. By making that argument, they were able to prevail. The government was able to prevail at the Court of Federal Claims level and also at the Federal Circuit level. Then, ironically enough, that argument was abandoned by the time it got to the Supreme Court. Okay, so what ultimately ended up happening as part of the Kingdom Ware decision? Well, not surprisingly to most practitioners who were following the case, the Supreme Court found that the Rule of Two set-aside requirement was a mandatory duty under the Veterans First Act. So what this meant was that the VA had to apply the Rule of Two to all of its contracting determinations as part of its acquisition process. So it was supposed to, it should have. In this case, it didn't, and the Supreme Court determined that it had, or it should have, gone through an analysis of whether or not two VOSBs or SDVOSBs, or at least two, could have adequately provided the services being obtained and provided those services at a reasonable price. And of course, if that happened, if that market research were done, then ultimately, and it was determined that two such companies existed, then it was a requirement under the Veterans First Act for the Department of Veterans Affairs to set aside that work. Now, what's really interesting about this case is not necessarily that result, but what was considered to be dicta in the opinion. When I say dicta, this is what happened. So as I mentioned before, the primary argument that the government had been making all the way up to reaching the Supreme Court was that the department had the ability to waive these mandatory set-aside requirements if it had already established that its contracting annual contracting goals were met. Okay, and the argument was primarily premised upon the prefatory language contained in the Veterans First statute. So what the VA had been arguing all the way up to the point where it got to the Supreme Court was that the purpose of the Veterans First Act was to assure that the VA met its annual contracting goals for VOSB and SDVOSB firms. If the agency determined that its goals were met, so the argument went, there was no need for the VA to adhere to the mandatory set-aside requirements set forth elsewhere in the Act. That's what we would call the operative language of the Act. So the operative language would not come into play if the contracting goals of the VA were already met. That's what the argument had been all the way through the Supreme Court level of litigation. Well, once it got to the Supreme Court, the Department of Veterans Affairs position changed. Okay, at that level, the government argued for the first time that the statute only required that contracts had to be set aside under a rule of two analysis, but not orders. Okay, under the FSS schedule, the orders that were made through FSS were not contracts. So the VA argued once it got to the Supreme Court, and because orders are not contracts and the Veterans First Act only speaks to contracts, then the mandatory requirement does not apply. Okay? That was the argument that was posed at the Supreme Court, and what the Supreme Court said was, well, look, we don't have to really get to this issue because you never raised it before, all right, but we're going to talk about it anyway, all right? And they ultimately concluded that FSS orders are in fact contracts within the normal meaning of that term. As practitioners, we would understand the term to mean. In fact, the Supreme Court did point to the definition of contracts that's set forth in the Federal Acquisition Regulations in reaching this conclusion. But the important point is the Supreme Court did not have to render a decision on that issue because it was raised so late in the game by the government. Despite that, it made a very straightforward statement regarding what it felt constituted a contract. And that's where the great interest comes in sort of the world of federal contracting today, at least the lingering issues that have been that have resulted from the decision, and why it remains to be important, and it's something that we're still talking about a year later. All right, so an order, according to the Supreme Court, is a contract. Well, so what, right? An order is a contract. It seems like that wouldn't be such a big deal. Well, here's why it's a big deal. It has long been, as we say here, the GSA's position that under the Small Business Act, the Rule of Two requirement is not necessary as it pertains to FSS orders. The decision to set aside contracts in connection with FSS orders is discretionary on the part of the agency. That's been the GSA's position, and that position is premised on a number of regulations. So FAR Part 8.4 identifies an exception from small business set-aside mandates that are found in FAR Part 19, and FAR Part 19 is the implementation of what can be found in the governing statute, the Small Business Act. Okay, so these regulations that we're talking about, 8.4 and FAR Part 19, are all supposed to be consistent with statutes that are issued by Congress, and the regulations themselves are supposed to implement dictates from Congress. And the GSA's position has been that based on FAR Part 8.4 and FAR Part 19, that this is precisely what occurred, and as a result of the exceptions that are identified in the FAR, that the FSS orders don't fall under the definition of a contract. They're accepted out by regulation, and as a result, FSS orders are not contracts. The GAO has taken the same position in a number of cases that preceded Kingdomware. Right? There's a There's one, Aldevera. It was issued in 2015, and in the Aldevera case, the GAO goes through precisely the analysis that I just articulated. It discusses FAR Part 8.4 and FAR Part 19 and identifies the fact that, hey, there are exceptions in the regulatory makeup as it pertains to what does or does not fall within the Small Business Act, and it has, at least in the past, before Kingdomware, taken the position that the GSA has taken. Now, SBA, on the other hand, has taken a contrary point of view. Based upon what SBA has said, the rule of two is mandatory for both contracts and orders, and once the Kingdomware case was issued by the Supreme Court, it has used the Kingdomware case as support for the position that it has long taken, that the Small Business Act should be applied across the board as it pertains to that band of contracts that are valued from $3,500 to $150,000, that, hey, you apply the rule of two, and if based on that analysis there are small businesses out there that can provide the product or services, then that's where these contracts need to go. They need to go to small businesses. In October of 2016, SBA issued a policy memo. Now, that would have been about 6 months or so after the Kingdomware case was issued by the Supreme Court. And in that policy memorandum, the SBA reiterated its position that rule of two has to apply across the board in the situations that we've been discussing, and that Kingdomware provides further support for that. And as late as June of this year, I was on a panel in Anchorage, Alaska, with the National 8A Association with that were SBA folks, with the associate director, associate counsel for the SBA, and the SBA's position on that has not changed. And what it means is you have these divergent points of view about what is and is not a contract. What the Supreme Court has said through Kingdomware is pretty straightforward and direct, but because it's dicta, we're not really sure what to make of it. And so what has resulted is confusion. So does the rule of two apply to FSS orders, or does it not? The Supreme Court and the SBA seem to say yes. In fact, they do say yes. You have other points of view out there which say, well, hey, wait a minute, we have regulatory direction that provides for something else. It's quite possible at some point in time that Congress will step in and address the issue in a more direct way to allay the confusion, to fix whatever issues there may be out there in terms of understanding when rule of two applies and when it does not. But as it stands right now, you have a lot of uncertainty out there. You have the potential to protest to the extent that you're a small business and you see something out there where you think it should have been set aside. We've had a number of those issues raised by clients, prospective clients that have called me, and that uncertainty lingers out there to even now, over a year later. So from the perspective of the government contractor, you need to be aware that this issue is out there. It is unsettled, and it will be unsettled until either through the courts, the GAO, or through the legislative process, there is more certainty provided in terms of when rule of two applies and when it does not. So that will conclude my comments about rule of two, and I thank everybody for listening. And to the extent that you do have any questions, there's my contact information there, and Jennifer's as well.
Great, thank you, Ed. That was very informative, and as we said, a timely topic. So thanks everybody for attending. As far as questions, please direct them directly to Ed, either by phone, which you can see right there, or to his email. This is being recorded, so if you need to go back for a refresher, you want a copy of the slides, we will have these recordings posted on our website at the end of the week. Our series continues next week and for the next 6 weeks after that with additional topics on government contracting. So thanks again, Ed, for sharing your time and your knowledge and expertise. He's a great resource for government contracting, and I highly encourage everybody who's on the line to reach out to him for additional information on this topic and others related to government contracting.